And you're listening to Northwest Tech Show on KMUZ. I'm Dave Duncan. And today we're going to kick things off, as we like to do, with a Creative Commons from the good folks at twit.tv.
This is Twit.
Some say, I don't know, is it hyperbole, Mike Masnick, to say the fate of the internet rests in the hands of these 9 justices?
Well, potentially, it may depend on what they have to say in ruling about these cases.
Justice Kagan, when she I listened to the oral arguments, which was great fun. Kathy Gellis, your contributor, was there in the room. Yep. She's admitted to the Supreme Court. Justice Kagan at one point said, "These are not the 9 greatest experts on the internet," and the room burst out in laughter, which I don't think is very common in the chambers. But she was, and other justices felt the same way, admitted that this is a big decision. So there were 2 of them, but this was Gonzalez versus Google, the family of a young woman who was killed, tragically killed in Paris in an ISIS terrorist attack. For some reason, the family decided to blame YouTube, even though there was no direct causal connection. And in particular, the YouTube algorithms recommending ISIS videos, radicalizing people. And it really threatens Section 230 of the Communications Decency Act, this 26 words that some say saved the internet, made the internet, that say that you're not responsible, whether it's a website or a chat room or our Discord or our Mastodon instance. We're not responsible for the content people or YouTube post there. That is not something we're publishing. So it gives us 2 rights. 1, the right to leave it up. 2, the right to take it down. We can't be sued for either.
Right.
Is that a fair? You have the best page on Tech Data. Somebody has directed you to this page on Section 230 because you got it wrong, and it's commonly wrong. In fact, I saw a Mastodon toot from you saying, "Would somebody please refer the New York Times to me before they write about Section 230? Because they just get it wrong." Why? What is it that people get wrong? Why don't they understand this?
There are so many things that they get that people get wrong about 230. It's hard to summarize them in a short form. That's one of the reasons I wrote that article that has all these different things. And what's funny is people get it wrong based on what they want the law to be. Often the exact opposite of what it is. Some people think that if you moderate too much, that you lose your 230 protections, for example, which the law is actually explicitly the opposite of that.
It's so you can moderate.
Exactly. And it was put in place because of a case that said the opposite, that there was, Prodigy was this company that had moderated and lost, and what became liable for content on their forums because they had moderated. And 230 was designed to protect that and fix that.
Ron Wyden, by the way, second time we've mentioned him, is the guy who wrote 230, and he kind of felt like it was needed because of the CDA. Like he said, we got to carve some safe harbor out for the internet so that people can publish, so they can have forums, they can have communities.
Yeah, and it's it's a very simple law in concept, which is this idea. The real idea behind it is that you want to put the liability on the party who actually did whatever is violating the law, rather than the tools that they use. And if you think of it that way, then it becomes a pretty straightforward.
It makes sense.
Yes.
Right. And you wrote it.
But for whatever reason, people have a lot of trouble with it. And they just really believe that, especially in this case, the real focus of the Gonzalez case was whether or not the algorithm, the recommendation algorithm, is protected by 230 or not protected by 230.
That was one. And I have to say, I came around a little bit. We had a bit of a debate. Jeff Jarvis spanked me on This Week in Google because I said, well, couldn't you? I mean, look, no one loves these algorithms. These algorithms are there to make more money, to make more sticky content, to promote content that keeps people watching. And I'm not saying it's intentional, but inadvertently, as a result, they tend to push more extreme content, more and more extreme content, because that keeps you engaged. So shouldn't they be liable for that?
So there are a couple. A couple things on that. One is, whether or not they actually do push more extreme content is there's less and less evidence of that. There were a couple of reports from 7 or 8 years ago that suggested that. There have been multiple studies in the last 3 to 4 years that have actually suggested that's not true. That what the companies have discovered to some extent is that if you're just pushing people further and further down an extremist rabbit hole, that's actually not good for business. It's your advertisers get kind of mad about it.
Well, that's true. Yeah, look at Twitter.
Users get angry and start to go elsewhere. There are all sorts of reasons why companies actually don't. There is this belief certainly that algorithms are only negative and bad. And the reality is that for the most part, many algorithms are actually somewhat helpful. I think the internet would be a lot worse without many of these.
Well, there was an amicus brief filed by Reddit moderators.
Yep.
Who said without algorithms we couldn't do our job. And this was the problem. And what's interesting, the justices actually seemed to get it. Even I was surprised. Brett Kavanaugh basically said, this isn't for us to decide. This is for Congress to decide. Justice Clarence Thomas said, algorithms, you got to have algorithms. Without algorithms, there's no internet. He likes those weird analogies. I think he talked about a pizza joint or something. But in any event, he got it. I was kind of impressed.
I mean,
go ahead.
It is an interesting question that point that without algorithms you can't have the internet. Obviously, we had the internet before algorithms when moderation was done manually. It does not scale.
It just doesn't scale. We had Yahoo, right?
Yeah.
Yahoo was done by humans.
Yeah.
But it was quickly superseded by Excite, Alta Vista, and eventually Google, who used algorithms.
And it is an interesting question. Is an algorithm, is it speech? Is it conduct? Is it a product feature? And there is a case that I don't believe has made it up to the Supreme Court. It's being considered by a court in Georgia about Snapchat getting sued over a speed filter that showed how fast you were going
yes.
when you posted a Snapchat.
I used that on the Shinkansen in Japan to show how fast I was going, but unfortunately people also use it while they're driving.
Right, and the point made by the plaintiffs, I believe, was that this encouraged people to use their phone while driving,
recklessly.
Right, and Snap ended up pulling the feature, making it kind of a moot point going forward. But that principle of is the way that a site that happens to host speech by its users, the way it operates. Is that itself speech by the publisher of the site? Is it tied into the speech of its users, or is it something besides speech? I think that is a fair and interesting legal question, but I'm sure Mike and Alex have thoughts there.
Yeah, it's a tricky thing, but it gets back to this simple question of who is the one who is actually violating the law, and what is the law that's being violated, and how is it being violated? So the Snap case in terms of the speed filter, I actually think there have been a couple different cases with that same sort of fact pattern, and I think the one that has gotten the most attention, which is Snap v. Lemon, I think that was decided incorrectly, where they said that Snap doesn't get 230 protections. That case is then gone back and is currently in discovery about whether or not Snap is actually liable. This was one of the mistakes that the New York Times recently made in their reporting. They said that the court said that Snap was liable, which has not actually been determined in a court yet. So if you look at that case as an example, what is it that Snap is actually doing? Right. So they have created this filter that tells you what your speed is. Is that encouraging speeding? That's kind of an open question, you could say, but even if it was, is that by itself violating the law? Is encouraging someone to speed by itself violating the law? It's not. So, the idea that there's some sort of legal liability here beyond that doesn't really make sense. The person who is violating the law is the person who's actually speeding. And so, putting the blame on the person who's actually speeding is the right thing to do. And all that 230 does in these cases, in this case, they got around 230, but, is make sure that you're talking about putting the legal liability on the party who's actually taking the action which violates the law.
Right, but Mike, product liability, product liability law does not forbid you to manufacture a product that could be dangerous. It's all a question of when you discover that the product is dangerous, who's
Well,
at fault.
here's a similar example. Who's responsible if a Tesla running full self-driving causes a fatality? Is it the driver who used the full self-driving? Under your argument, Mike, it would be, but I think Tesla advertising full self-driving when it clearly doesn't work might give them some liability too, right?
Right. What if you take advice from ChatGPT?
Yeah. Oh, there's your problem right there. The court in the Lemon versus Snap said, well, Snapchat made a product that was unsafe, in effect, which doesn't seem unreasonable to me. I mean,
right, and you're free to make products that are unsafe. It's just you'll be
liable for it. And clearly, the kids who caused the fatal crash were the main culprits. But Snapchat does have a responsibility. Don't they not to make stuff that encourages bad behavior? I don't know.
But I think that it's one thing for you to build a tool that actually generates behavior, which is what all tools do. I mean, we oftentimes say when we're talking about measurement is that you don't measure what matters. What you measure matters. It becomes something that's important. And if you talk to YouTubers, for instance, they are obsessed with the algorithm. They are obsessed with what does the algorithm do with when people watch this a certain amount of time? How does it handle the thumbnails? How does it do all these other things? So behavior is definitely driven by those algorithms. And so the thing is that that's when you're generating those things, if it's generating bad behavior, that's one thing. But then the other side of this is like when people put things on TikTok that are dangerous, do you have I think part of this is, and this is where 230, I think, comes into a little bit more of a situation. When you're creating something as a company, you're still probably liable. When you are allowing content to go onto your site that is driving people towards a behavior, some kind of herd behavior that is damaging, are you liable for that? Now, I think that I think the idea of tampering with 230 is terrifying. I don't think that there's any version of this, any way that you can unwrap 230 in a way. And I feel so strongly about it that when someone on Twitter or somewhere else posts anything that's positive about dismantling or even tweaking 230, I immediately make an intelligence decision about them.
I agree.
I disagree. It's not like I disagree with you. It is, I will never believe
You're an idiot.
on anything ever again. It is there's this, a lot of times we think of risk as the chances of something going wrong multiplied by the consequences. That is the math of risk, right? And the chances of something going wrong are medium. The consequences are catastrophic. Yeah. And you're just talking about fiddling with something that we've built and whether it was perfect or not, it doesn't matter anymore.
Well, actually, that was interesting. One of the judges, I think it was Kavanaugh, correct me if I'm wrong, Mike, did in effect say that the consequences to the economy of changing 230 could be dire.
Yeah, that was Kavanaugh. Kavanaugh, honestly, and I wrote this, I'm kind of hoping that he writes whatever the decision is out of this. And I would not consider myself, generally speaking, a Brett Kavanaugh fan. But I was, he's ruled on a couple cases that sort of touched on internet and free speech issues and really actually does seem to get that and to get the deeper nuances here. And that became clear in the oral arguments in both of the cases last week, that he really seems to recognize that getting this wrong will have massive consequences for both speech and for sort of economic development and innovation. And so he's the one who seems most spooked by the possibility of getting this wrong. And I think that is the right attitude to have.
Yeah. Is it
possible to narrow Section 230?
There's a good question.
Without overturning it,
not that I've seen. Of course, I am open to the idea that is possible if somebody could show me a way to do that. And to date, nobody has shown me a way that doesn't really obliterate the entire law. Every sort of narrow change to 230 that I've seen in reality obliterates the law. And Kathy Gellis, my colleague, wrote a piece a couple of years ago, I think, that effectively said that, which is that, any reform to 230 really is a repeal to 230. And this gets somewhat into the weeds, but it's sort of how 230 actually works and what the mechanism is, because I think people sort of get confused by that. The reality is that Section 230 is the sort of, procedural benefit that gets rid of frivolous cases very early on. And if you change that in any way, all you're really doing is asking people to have to go through long and expensive court processes in order to prove that they were right in the first place. And once you've sort of opened up the legal process and the expensive
This
part,
reminds me of fair use.
there are fantastic similarities to sort of the fair use thing.
Because fair use means you go to court.
Right. I mean, that's the famous Larry Lessig line is fair use just means the right to hire a lawyer.
Yeah.
Right. Because that's all it is. And you're going to have to fight over it. And because of that, what happens? We really don't have fair use.
It's
we don't
a chilling effect. Yeah. I am very careful
yeah.
about what we put on this podcast because YouTube will take it down, even though it's fair. I know it's fair use. And if I asked them, they'd say so. Certainly a lawyer would. Doesn't matter. It's a chilling effect because I'm not going to go to court to defend it.
Right. So almost any reform, and I would say every reform that I've seen of 230 really does that. It basically just means you're going to have to go through a very long and very expensive court process, which means many companies won't. They'll just back down. And it sort of gives people a heckler's veto that would stop whatever it is those companies are doing,
That's a really
whether it's good or bad.
That's an excellent point. Because just even slicing a sliver off means suddenly, well, now the court has to decide. So you really by not keeping it an integral whole, the whole is what protects you against frivolous lawsuits. Any sliver, does that make sense, Owen? That any sliver, then now suddenly we have to adjudicate.
Well, I think I think that Mike does an excellent point. Mike does an excellent job of untangling like what is actually in Section 230, versus say the First Amendment, and they definitely are intertwined in that, like your First Amendment right to put something on your website or not is kind of, is fundamental to understanding how Section 230 plays out. But, I do wonder if what we're after is the underlying speech or conduct and putting the right responsibility, the right liability where it belongs. We do have to look at these cases where it's, is this really speech? Is this really,
Well, and I would say, and this is more about the Snap versus Lemon case, you don't want a carte blanche to let companies create anything they want. And, you do want some product liability. You don't want to say Section 230 extends so far that a company can do anything it wants. And if somebody does something stupid with it, it's their fault.
I think that the thing is that the company's doing something is one thing, their users doing something. So I think that's the important piece is when their user puts something on their site, then that protects the company from that. When the company does something, and I've worked with a lot of these companies, and so they pay a lot of attention to liability because generally this is a very different thing.
Well, and that was the debate,
case,
though.
You're talking about claiming.
That was the debate in court was, did Google's algorithm, was that the company doing something, right?
Yeah, and I think that, the company creating a product that affects many, many things and may inadvertently affect something that they're continuing to work on, I think is one thing. Them creating a contest that obviously drives people towards an unhealthy behavior is a different thing. And I think that I do think that an algorithm that is generally working for most people and happen to do something which they haven't even proven yet, is probably, something that is very hard to plan. And again, I think that 230 is imperfect. I think that it probably could have been written better with hindsight. They were writing it. We have to remember that 230 was written when they had no idea what was going to happen. Like it was. And so now we've built but now it is a cornerstone, of a giant building, which forms the world's economy. And you're talking about like, well, that thing was a little
off here.
It should have been. Why don't we just take this centerpiece, this part out of it? And if it, again, the consequences is, we don't get it right. It'll have the entire
building
corner
falls over.
It's like saying, I think we're going to change and have the gas be something slightly different, and all engines and all all gas stations have to change if we do this, or someone can pass a law that forces everybody to change everything across the United States.
Now you're talking Formula One. That's a different matter entirely.
But we're going to change the formula of gas, and we're going to just say that's going to, we'll just tweak it a little bit and see how it works. And, it's a big economy that you're starting about turning over. So I think it's so dangerous. Like it is, it's again, what we call fissionable material. Like you could really cause so much damage.
There was a quote I saw yesterday that Section 230 is the load-bearing wall of the internet, and I think there's some truth to that. And just to make up an important point here, when you start to talk about the difference between speech and conduct, which is where a lot of these discussions are going, and sort of where I think Owen was going with his comments, and where like the Julia Angwin New York Times opinion piece last week was saying, oh, separate out speech and conduct. The problem is that every single plaintiff and every single plaintiff's lawyer know exactly what they'll do in that case. And that is they will declare everything to be conduct rather than speech. And then you're at that point that I was talking about where you have to litigate it. And once you have to litigate it, you've lost all of the value of Section 230. Even if the defendants in all of these cases are going to win, just the fact that you've now set it up that you have to litigate the question of 230 and then go to discovery, perhaps go to trial, all this stuff that is extremely expensive that will force most companies to either change their practices or settle cases too early, even if they would have won in the long run, effectively wipes out the tremendous value and benefits of Section 230.
You're listening to Northwest Tech Show on KMUZ. That was a Creative Commons clip from the good folks at twit.tv. That was This Week in Tech 916, Supreme Court on Section 230. I'm Dave Duncan, and today I'm joined by author, historian, and adjunct professor of history, James Masnov. Hello, James.
Hey there.
It was Section 230 was part of the Communications Decency Act, which was struck down as unconstitutional. It essentially said that the whole internet had to be brought to the level of the child unless they did age verification, which was obviously a no-go. But it was considered separable. Can you tell us a little bit about separability?
Severability. Yes, it's an aspect that different legal scholars and legal historians sort of debate on its constitutionality, but it's basically the idea that dealing with the court's power of judicial review to strike down laws it finds that the court finds unconstitutional. There's sort of debate over whether the law in question should be struck down in its totality, or if certain aspects of it can be salvaged for the sort of subtext of constitutionality, even if there are other aspects of the law that are clearly unconstitutional. And so this concept of severability comes in, which is, well, we don't have to throw out the whole thing. We can save those things that are not unconstitutional.
As it was with the Communications Decency Act of the 90s, Section 230 survived, and that was a time when the internet was pretty new, and it really cleared up a lot of stuff that otherwise would have had to have done decades maybe of court cases to clarify who was liable for what. And the main section of it says that when you are making a post on a platform that you don't own, that you are responsible for what you write, not the platform. And that's resolvable at a very early stage in any legal complaint, so that you don't break people financially simply by making a lot of frivolous claims that this or that post that someone else made is your fault because you're the big pockets. So that made it possible for things like Wikipedia and many other user contributed stuff. Well, YouTube, really, in a way, part of it at least. Social media accounts, that's really very centered to it.
My understanding in terms of the controversy, however, is the sort of aspect of curation, and what level of curation is a platform allowed to be responsible for before it then leans into something closer to publishing, and publishers don't have the same sort of protections as a platform. And this is the sort of gray area that's being mitigated right now.
Yeah. So the New York Times hires a writer and they do an article, then that is clearly, if something is libelous or otherwise incorrect in that article, then clearly the New York Times is responsible because they were the only ones involved with this. So it doesn't protect in that circumstance, but someone comments on it, comments on the story, just they have an open interface where anyone from the public can log in and do a comment, then they would be protected under Section 230 in the current interpretations of it. The other part of Section 230 was generally, if you do any curation at all, you're now considered a publisher. So the second part of 230 said that mere moderation did not make you a publisher. So you were able to, because without that, you're kind of going into the zones where either you moderate nothing to avoid being considered the publisher of the things that you say are okay, and the place just turns into an unusable hellscape, or you moderate everything, usually by saying posts are not visible until someone explicitly allows them, and you have a very sterile and very lightly used kind of forum.
Right.
So,
and with the YouTube aspect of these cases in question, listening to oral arguments the other day in this case, what struck me was the different arguments on either side of, are YouTube recommendations a form of publishing because they are prioritizing one video over another? And I thought that was a kind of interesting argument, regardless of what one thinks, what side one thinks on it. It's an interesting idea.
So that was, I think, invoked also an anti-terrorism act,
right. Yep.
Where they were saying, it's a crime to give comfort and aid and support to terrorists, and so the sort of refinements here are, it's like, okay, well, if I give a terrorist a taxi cab ride, am I aiding and assisting? So it has to be. It's generally considered to be something more specific to support the terrorist act, and not just like selling them groceries or something.
Right.
And that's where these cases, I know one of them was called Gonzalez versus Google, and there was, okay, a family member has been killed by terrorists, and there are terrorist videos on Google, therefore sue Google. And it wasn't implied that the terrorists watched those particular videos and that specific terrorist watched videos and got activated or anything like that, but just in general, it's potential for YouTube to radicalize people, which is a real problem. I think it needs to be dealt with. I just don't think it needs to be dealt with in this way, that just sort of shuts down all communications. Like, well, if you don't know everything about, it's kind of like know your customer laws. If you don't know everything about someone, then you can't interact with them in any way.
Yeah, that's absurd. So the thing about it to me, though, is that it's clearly, Section 230 is clearly a subsidy of sorts. It is an exemption provided to certain corporations by the government. And so because of that, do you think that that's, I heard your cynicism there. Would you say that that's...
Well, I think this is, what you just said. What you just said is very commonly what is pulled out as, reasons to hate Section 230. And I think it's fine to say it's not perfect, but it's a little misleading, because if Section 230 was struck down, the big corporate players would manage to survive. What it would do is make sure that new companies would never be able to compete with them, because they have the hundreds of millions of dollars in content filtering technology already that they've already paid for or can afford to pay for. And I think in any court you go into, it's like, if you're using the best technology that exists, even if it doesn't really do the job very well, it's kind of hard to hit you with any liability for, well, you should have done better. It's like, how?
Right.
But
to me, though, it's a matter of degrees. Like, I don't buy the argument on either extreme of the issue. I think that getting rid of 230 is a bad idea. I think 230 as it currently exists is a bad idea. To me, it's a matter of debating where in between those poles something should be decided or reformed. I think 230 reform makes sense to me, but the idea of throwing it out makes no sense to me at all.
Yeah, and I really struggle with the idea of the reform itself because it's being pushed for completely opposite reasons on both sides. You know, on one side, it's like, well, you know, it gives too much power to the social media companies that, and you know, as the government, we don't like them having that much power. And on the other side, it's, you know, and they're saying basically that it's you know, the things you promote is going to be a problem, or it's not, or you're allowing too much extremist content or whatever. And on the other side, it's like, hey, you're moderating our extremist content. You know, stop it. We want to make it you legally obliged to carry content that you don't believe in, because we have freedom of speech, but the platform doesn't, apparently, in that theory, where it's like, you must repeat speech you don't agree with. Why? I don't know. You know, it's a big wide internet. It's like
Yeah.
you have an audience and we want that audience. And so you have to give us that audience rather than go be on another service where it's wall-to-wall nutcakes and nobody listens to you.
Right. Do you feel the same way about, it's a sort of antiquated comparison, but I think it serves a purpose, like the phone company.
Mm-hmm.
You know, if there happens to be a phone company that gets a certain amount of crazies over the rest of the, you know, over the other phone companies, nevertheless, I don't think that phone company should be held responsible for horrible things that's discussed over their phone line.
To me, it seems like, okay, well, it's a good example to throw out in the arena, but it is, again, talking about a one-to-one call versus mass media. So I think that's a difference. There are a lot of things where a difference in scale is a difference in kind.
Absolutely.
You know, yeah, I mean, in libel law, you know, if you privately say over a phone conversation that so and so is, you know what, then that's not really a problem because it wasn't public.
Right.
So,
well, what's also interesting about that, if you're talking about libel or slander, because I hear so-called free speech absolutists say they would want to get rid of those kinds of standards, which to me is absurd, because I think one of the things that legitimizes libel laws is that the truth is a defense. If you get sued for libel and it's found that what you were saying is the truth, then that absolves you. I think that makes perfect sense.
Yeah, and you shouldn't be dragged into court because someone doesn't like that you told the truth about them.
Right. Now, to further complicate these cases, what do you think then also about this added layer of complexity, which is sort of the state actor issue, as you've seen with some of Matt Taibbi's work and things like that, that you had members of the FBI reaching out to Twitter. You also had Donald Trump. This isn't this is a bipartisan problem. You know, you've had people from both political parties do this, reach out to Twitter and social media companies and ask them to take things down that did not in and of themselves violate their terms of service.
Yeah.
So that seems to be another level of complexity to this issue.
Yeah, and that seems separate. I mean, always there is the case of how much can the government get away with just kind of doing without any legal basis, like WikiLeaks. You know, the vice president reaches out to the credit card companies and says basically, yeah, I would really appreciate it if you cut off these guys' money. And they did. Right. They just said, okay, that's not, you know, if you try to give a credit card donation to them, doesn't work. Right. You know, so that's an interesting kind of, they're not saying you can't do the speech. They're just using their influence to make sure you can't get paid for it. Mm-hmm. Which is, you know, a subtle distinction, but it is a distinction. You know, technically they didn't stop you from speaking. They just stopped you from being paid to speak. And so it is kind of with the social media and the algorithm, where it, on fine points of how the algorithm is tuned, it depends on if you get this extended reach into the community where more people see your messaging. And I think there it really has to do with the intent of the algorithm, because you can't, algorithms by its nature don't have people in the loop. So it's like you anything that happens because of the algorithm that wasn't intended, it's like, well, it's always going to have unintended results. And I think at that point you have to say, well, you can say on one hand, we can't do this thing we want to do, which is have a social media at a scale of this without enough people to actually moderate the content. And you could say, oh, okay, well, I guess you have to have algorithms because that's what you want to do. On the other side, you have to say, well, do you have a right to have a business that operates at a level that you can't control what's going on?
Okay, yeah, I was just going to ask you something similar to that, which is, should there be criminal and or civil penalties for a social media company or something like it clearly violating its terms of service on a regular basis? Because it seems to me that without having to get into 230 or the free speech aspects of this stuff, that's just a clear sort of instance of fraud. And if
Making money by deception, how?
Yeah, if a company presents itself as having a certain level of a terms of service, and then is throwing people off, even though they are not violating those terms of services, it's fraudulent.
Well, I think people have a right to throw you off their platform for no reason or any reason, as long as it's not like a discrimination reason. I think that's the only limits on that. There is this problem where platforms have gotten big enough that they have taken the place of the public square for discourse. But at what point did they give up their rights as a individual company that's an artificial person under the law? At what point they give up their rights to operate freely?
But doesn't the lack of consistency in sort of policing and enforcing their terms of service,
No.
is that not an example of arbitrary power?
Well, why would you think they don't have a private company doesn't have arbitrary power over its own platform?
Well, because they're provided this legal exemption. That's the whole argument.
Okay. I guess the question, okay, what is terms of service? So that is just in this case, it's something that's thrown out there as, you, the user of this service, agree to the following things. And maybe it says some things about, okay, and this is what, maybe they have a privacy policy or something where it says we promise not to do X, Y, and Z, but most terms of service I've seen pretty much say the company can do anything they want and they can change the terms of service at any time. And then you have layered on top of that the fact that most of these terms of service, or terms of service in general in our lives, are so overwhelmingly long relative to how much benefit we get from them, that you could spend more than 100% of your life reading terms of service for all the services your life touches. And so when it is literally impossible for you to read all the terms of service, should they even amount to anything? And right now they say, yeah.
I agree with everything you just said. There's the arbitrariness that I'm concerned about, but there's also just the unbelievable level of bureaucracy involved, that the people just they click yes to things and they don't necessarily know always what they're signing up for, and that those terms of service can change at any time. I understand all of that. My point is that some of these social media companies have said that a user has violated a term of service, and that's why they get thrown off. And then later it's found that there was no violation of terms of service at all.
Yeah, and that's back to the algorithm.
Should there be culpability for companies that do that knowingly?
That goes back to the question of, hey, if this is the only thing that's possible, then do we just say, well, okay, you did everything that was possible? Or do you say, well, companies shouldn't be so big that it's impossible for them to comply with terms of service that they state? Because all the time, any story you hear, complained about on, the various social boards where people they're like, hey, YouTube threw me off for no reason. And they said I violated terms of service, but they won't tell me what the terms of service were. And, it was me doing all unique content, and all of a sudden it's terms of service violation. And
and they refuse to tell me anything. What? That sort of thing comes up all the time. And usually what it comes down to is, okay, an algorithm flagged it for, what it thought was a terms of service violation. And but there wasn't enough people to meaningfully review that. And it's sort of like the Texas social statute, where they're trying to say, well, anything over 50 million regular users then is liable. And, it's like they can't moderate the content of politicians or whatever their, pet group was. And it was like, okay, well, since it's impossible to do what that law says, basically you've just made it illegal to have social media sites over 50 million regular users. And maybe that's a good thing. Why does everyone have to be all piled together under one platform's control, where they're essentially controlling all the public discourse?
Do you think that there's a certain level of reform that should be done to 230?
In theory, yes. In practice, I haven't heard anything that sounds like anything but a complete disaster.
Yeah.
So, it's like, the thing I would least like to happen is little guys, you, me, local nonprofits, whatever, things that operate below the scale of, 1 billion users, suddenly having this impossible compliance regime that basically says, shut up. You can't speak without creating a huge liability for yourself. So you just can't speak.
Well, and isn't that part of the threat of the way Amazon servers have such a massive, they take up a lot of the internet, this idea that a handful of companies sort of almost have like domain over the internet itself. Isn't that part of the problem?
Yeah, that's a sociological problem. And it's a problem with the markets, and it's a problem with allowing, unlimited absorption of your competitors, as long as it's not affecting the price of services. And that turns out, I think, to be a really horrible scale to judge on. That was a Robert Borkism, where it was like, okay, this is what anti-monopoly means. This is what we need to worry about. What is the price to the consumer? And when you're giving out services that are free to the consumer, you can do whatever you like. And the fact that it's giving you a disproportionate control over society, and potentially the ability to, alter the government by, moving elections any way you want to, that's not a problem. Yeah, that's a problem.
Right.
So I want to get back to some old school, where the totality of the impact, if it hurts society overall, that to allow someone to gather so much power that essentially there is no free market, where one of the players in the market can control the rules.
Right. Do you foresee a day where there's any sort of bipartisan antitrust movement, or would that concern you as well?
Right now, it's kind of hard to see any bipartisanism, except where, okay, if something threatens their ability to raise money, then they'd all be against that. Even, just to go back to Bork, when he was going through some confirmation hearing, his video rental habit of porn videos at the local video shop was brought out as something during his confirmations to embarrass him. And all of a sudden, 10 seconds later, we have a law saying that your video rentals are private information. So it's like, as soon as it affects the people in power, then there's a rule against abusing them. But before that, it was like, hey, any data that's logged with a third party is now free game, even though all of our most personal data tends to be logged with a third party now. It's not this idea that all my email that's stored on an email server is business records is just ridiculous.
Right. Now, this is a little bit of a shameless plug, but you mentioned Robert Bork twice. I was going to let it go the first time, but I discuss him a bit in my my book about the Supreme Court that's coming out. I actually
excellent.
Spent some time on him because his confirmation process, which he failed, he was not appointed to the court. I sort of take a look at that because I feel like it's been framed, particularly by conservatives, in a completely disingenuous way. And I note how he was just so supremely unqualified for the position, just by his own words.
And we've seen that in recent confirmations, was they rammed through their slate of ultra-conservative Supreme Court nominations. It was like, well, didn't you have this, didn't you sexually abuse people in college? And it's like, well, let's not look into that. And, and there's no reason to ruin this person's life by, digging into stuff that happened that long ago. And it's like, I don't think it's just about his life. It's about the United States supreme power,
and
making sure they're good people. Right. Yeah. So it's not about you. is what I wish someone would say to them when they're whining about, amongst my extremely privileged life, I can't get this major step up in power, because of allegations of something long ago. It's like, can we just get someone who doesn't have lots of allegations against them? I think we've got 2 or 3.
Right. Well, so you would ultimately like to see some sort of antitrust movement, or that would concern you?
Yeah. Well, okay. So I think one of the things that really rolled us in the gutter as a society was Citizens United. As soon as you said dumping unlimited anonymous money any which way you want is fine, then that was like, okay, the overall benefit of the country doesn't matter anymore. It's just about, let's make sure, because life isn't fair for everyone at the same time, all the time. All this unlimited, black money is about being able to change the rules and saying, well, we can't be fair to everyone, so let's be fair to the 1% of 1% and unfair to the rest of us.
We may not find ourselves, it sounds to me like we might not find ourselves in agreement on the Citizens United thing, which initially I was enormously against. But as I looked more and more into the jurisprudence of it, there were some things that I don't know how you address the free speech issue, which is what it ended up hinging on. It didn't initially, but during the oral arguments, it became a free speech issue.
Yeah.
Almost.
I guess my issue is taking the rights and privileges and protections that were meant to protect the least advantaged of us against the large guy or the government, and sometimes the large guy was the government, and say, now let's apply that to the most powerful people in society against the interests of everyone else.
Right.
And let's turn all of our rights into a way why we have to be in perpetual slavery. I think you have to look at the end result to a certain degree. And, if you're going to be unfair to someone, I say, be unfair to the person that already has everything,
Sure.
That give other people a chance. That is how a society stops from being completely stale. If you say, well, however hard this person worked to get their monopoly, to say, okay, and now I own this market forever, I earned it, I think is missing the point.
I agree with you there. The Citizens United decision also protected the free speech rights and the use of money for speech, not just for corporations, but also for nonprofits like the ACLU and labor union. Just that it was
the overall effect. What was the overall effect, though? It was to bury those people. To so overcome them with greater amounts of money. And we also have media where it's okay to lie.
Well, the decision had to do with not allowing a documentary to air on streaming television in 2008. That's where it came from. Sure. And I mean, that's really the impetus of the entire conversation.
I would have rather have seen that be a one-off decision, and for what it cost us, to heck with weird documentaries. I think there's so much room. We have so much free speech. We have people going on TV and just telling easily disprovable lies over and over and over and over and over and over, and getting a huge amount of coverage, getting a lot of free television time to say their stuff. And, if social media doesn't amplify the opinions of, kind of the 12 thought leaders on the social media and, flood everyone's in timelines with that, then that's, violating their freedom of speech to absolutely dominate everybody. It just, it doesn't pass the sniff test at some point. And it comes back to scale is different. That's a thing that's very hard to capture in law, is you say, well, I'm protecting this person, and therefore when this zillionaire, uses that same idea to dump on society, fine, we got to be, to protect this one poor person, we got to, dump on society. It's like, remind me the purpose of law and social orders and norms. It's to keep us out of those situations.
It runs in the opposite direction as well. Like this happened in the 1980s or so, 70s, 80s with shopping malls, which was that shopping malls became more and more seen as a public square, to the point that protesters started occupying the not storefronts themselves, but those free spaces in the middle of malls.
Did that resolve, or did malls simply went away before they ever really fully resolved that?
Well, no, it's muddy. There have been court decisions saying that that because those spaces began to be regarded as public spaces, that there should be some sort of leaning into free speech rights in those areas. And so, again, it's complicated. I agree with everything you said, and yet it goes in the other direction, which is the more something becomes a public square, the more you have to consider free speech rights.
Yeah. And also there is, is there any other public squares? And should we make more public squares?
Right.
Sometimes private entities, they come in and they occupy this location in the ecosystem of our lives. And yet they look stunned when they're expected to provide the same rights as occurred in the thing before they took it over.
Right.
And I think that's that's kind of a sniff test thing. It's like, so for real, you thought you were going to essentially eliminate the public square by taking over the public square and then applying your own rules to it?
Right. Okay, so I'm a little confused then. I thought you were saying that as private companies, they don't need to consider free speech and public square issues, but what you just said makes me think that you do think that. So
it's it's the combination is, I would rather we maintain actual public squares. I think my problem is sometimes is simply them pushing out of the ecosystem of our lives, the place where we had an opportunity to do X, Y, and Z. Yeah. They push it out, they take it for their private benefit, and just as a side effect, as an externality of their business, society loses its public square. So for that wrong, perhaps they should be obliged to provide some public functions. But at the same time, it's just like, why did we let that happen in the first place?
Well, and you know what? You're speaking to something that actually has quite a long history in the United States. I've talked to environmental historians who are a little bit closer to this issue than I am, but I find it fascinating that as you see the Industrial Revolution sort of unfold over the 1800s in the early United States, that they were reckoning with the same issue. Like at one point, it was a lot of nature around you, and then it kept getting gobbled up by the building of cities and industrialization. That the idea of public parks really didn't come into being until the middle of the 1800s, because there's like, if we don't start building parks, we're not going to have these sort of oases of nature anymore, these sort of public spaces. And it was only then that there was a move towards sort of creating parameters specifically for public spaces.
Yeah.
And this has been an ongoing issue for a long time.
I think that's the key. What you just said is the key to my feelings about this, is that it, in general, I like for the rules to be fairly applied to everyone. And what we have is sometimes people figure out how to, legally hose everybody. Yeah. And at that point, I think it's like, you know what? we're not obliged to just sit here while you crush our throats. Whether it's legal or not, we're going to fight back. And I think to a certain degree, as a country, as a society, there's norms, right? And when people follow the norms, you don't have to make as many laws. And
Absolutely.
so that's I guess that's the conflict I'm seeing, is where the norms of, hey, people should have breathable air. There are limits to what you should do that hurt people in your pursuit of a short-term buck. And on the other side, it'll be like, well, looking at the charter for a corporation, it says all I'm supposed to do is optimize money for my shareholders, and if I don't do that, I'm doing something wrong. I'm obliged to do everything I can get away with. This is essentially what they're saying, and I'm like, okay, well, we'll do our best to fight that.
Yeah, I in many ways think of myself as a sort of like small C capitalist, in the sense of like I believe in entrepreneurship and the rights of artists and inventors, and this sort of like small scale, sort of true free enterprise. But built into all of that is this deep complication of, once you get to the corporate level, then it's a monster that's gobbling everything up, and it turns into eternal profits and eternal growth.
Yeah.
And that's where it becomes insidious.
I think we were just talking the last time about, you can give as much rights as you want to creators, but as long as the practice is whatever rights you got, sign them over. Well, then your rights don't matter. They're each one is kind of passed with, hey, we're doing this to help the little guy, and not paying any attention that it is giving them zero additional leverage.
Absolutely.
For the most part. Yeah. All right, sir. Well, I think we've run over your time, so I really appreciate this conversation.
Great as always.
Yeah, this is these are the fights that are determining our reality. So love it or hate it, the internet has a huge part in our lives, and the rules like this have a huge effect on how that internet will look. And my hope is, I like that technology is a force amplifier, and I like as much as possible for it to be a force amplifier for the little guy, because that keeps things dynamic, empowering the individual. Yay. As soon as it gets rolled up into tools that large corporations use to further control society, I think that's, hey, big money should come with big regulation, is my thought. It's like, I want little regulation on the small guy so new things can happen, get started, get rolling, get momentum. And when they ultimately go in a direction that hurts everybody, that society should have some recourse for that.
I completely agree with you there. Absolutely.
Again, I'm Dave Duncan. I've been joined today by James Masnov, independent historian, author, and adjunct professor of history. Thanks, James.
Thank you.
And with that, we've done it again. Spent an hour talking about technology and how a better understanding of it can lead to better outcomes at home, at work, and in your civic engagement. I hope you'll join us to continue these discussions next Wednesday and every Wednesday, noon to 1 o'clock on Northwest Tech Show.